We've actually had a few rulings go in favor of President Trump, so I thought that we could talk about one of them. I was going to introduce it by saying this is one of the cases where Democrats have filed a lawsuit to try to stop President Trump from being the president, but that would only narrow it down to like one of about 30. But there have been a few where actually the judges have ruled in favor of President Trump, and this is one of them. You can see here from the caption, this is the National Treasury Employees Union, which is I think it includes the IRS people, versus Donald Trump. And this judge ruled just, I think, yesterday. And of course, you'll be watching this later, so that doesn't mean anything. But I do have the timeline in one of the later slides. But I mean, watching all these Democrats file lawsuits to try to stop Trump, it's like a game of whack-a-mole. It's just every time you turn around, they file another lawsuit. And I don't know how, because with the U.S. aid funding cut off, how are they paying for this, right? So here are the basic facts of the case. This is the National Treasury Employees Union, NTEU, and 4 other unions sued President Trump. I was actually going to put the caption up for that, but it was way too long. It was like over a page just to show all these different unions' names on here. And they were demanding a temporary restraining order or preliminary injunction to stop mass layoffs of probationary federal employees, large-scale reductions in force, and a deferred resignation program. Imagine a world where you never have to come into work, you have the productivity of a potted plant, and you can still sue if they try to fire you. Wouldn't that be a nice world to live in? Here is a timeline of the different events in this particular case. So on January 20th, that's when OPM directed the agencies to review probationary employees. I think OPM was the Office of Personnel Management, I think, for the government. Then on February 5th, the agencies submitted retention justifications. February 11th, Trump issued the executive order for large-scale RIFs. And on February 12th, the lawsuit was filed by the unions. That one day. They filed it one day later. They basically had this complaint ready to go, like it was saved in draft form and just ready to file it. I mean, is that not a good sign, really? They're probably not doing any work at all, but somehow they have this complaint ready to go. They must be looking around like, you know what? The way we are, we definitely should be fired because we're not doing anything. So the one thing we need to do is make sure that we have this complaint ready to file when they do fire us. So we have it ready to go. One day later, they filed it. And then February 20th, that is when this court denied the preliminary injunction. So that's the opinion we're actually talking about right now, is that one from February 20th. So looking at the complaint, here were basically the causes of action that these different unions were trying to sue President Trump on. These are simplified a little bit just because I don't like slides when they look like a barcode. So I have simplified this a little bit. The first cause of action, violation of separation of powers. The unions argued that the president's actions undermined Congress's constitutional authority to set and fund federal agencies. Number 2, they sued in violation, saying that President Trump violated the statutory RIF procedures, claimed that the mass layoffs violated 5 U.S.C. 3502 and related regulations, including improper competitive area definitions and ignoring tenure and performance considerations. Can you believe that? They actually, for the government, they define improper competitive area definitions. What kind of competitive areas do they really have with government employees? Like what? I think the most competitive thing you'd see at a government location somewhere would be when 2 guys showed up for the last donut in the break room. That's probably the most competitive thing anyone would ever see at a government location. Now, once President Trump's been in for a while, I think he's going to clean house and it will be different. But in the past, come on. Okay, and then hopefully none of you work for the government who disagree with me, because you've probably stopped watching already if you do. And number 3, they claimed a violation of the Administrative Procedure Act, the APA. They alleged that the executive actions were arbitrary, capricious, and not in accordance with the law under the APA. So the plaintiffs were asking for a temporary restraining order, or a TRO, and here is the test that they would have to meet in order to get the TRO. They'd have to show a likelihood of success on the merits, they'd have to show irreparable harm in the absence of relief, a balance of equities that favors the moving party, and they'd have to show that the public interest supports the injunction. Now, if this looks kind of familiar, maybe you saw this in my video from last week about the district court case with Doge access to the Treasury Department records, payment systems, because that was a TRO as well. So the same test applied here, and I was excited because we'd already gone over it. So I felt like I already knew the answer. But guess what? We don't even get to use it. I'll tell you in just a minute why, but it was such a bummer. It's like that time in class when you know the answer, and then right when you're going to raise your hand, the fire alarm goes off. You're like, that's the one time, like, let's just stay in class. Let me answer this. It was the one thing I knew. Anyway, so this would have been the standard, but the court went down a different path. So this is why the court didn't use the TRO standard, because the court said it was a jurisdictional issue. They said the court likely lacks subject matter jurisdiction, and it claimed that these claims must go to the Federal Labor Relations Authority, the FLRA. So the TRO, or preliminary injunction, was denied, and the court ruled that President Trump's mass layoffs could proceed. So that's pretty wild. Jurisdiction, that the court said it didn't have subject matter jurisdiction. And this was an Obama-appointed judge, so I thought the jurisdiction would be get Trump, because that seems to work, right? I mean, all of these cases that have been filed, they're all being forum shopped. They're finding the best judges who are, they have Nancy Pelosi posters on their wall, and they just still are really into, they probably have, the Kamala Harris, Tim Walz sweaters that they wear at night. Like, those are the kind of judges they're finding for all of these cases. This one was an Obama-appointed judge, but he actually ruled basically in favor of Trump because he said he lacked subject matter jurisdiction. So if you're wondering how clear-cut this case must have been, that it had to go to the FLRA, it had to be really clear-cut for this Obama-appointed judge to actually say, okay, I don't have subject matter jurisdiction, so I'm going to have to let this go. I mean, it must have been such a no-brainer, because I'm sure if he could have acted a little dumb just to get Trump, he probably would have. I mean, all the rest of them are. What are there, 30 of them now? So, sorry, does that sound like I have a bad attitude? Look, they're getting the most progressive leftist judges that are there. That's where they're filing these cases. So if you actually see one go in favor of Trump, that's really big, because you're starting from that hand-picked pool. So the judge was Judge Cooper. He took no position on the merits. So the actual merits of the case he didn't look at all. He just said, I lack subject matter jurisdiction. This is the wrong forum. You need to file it in the FLRA. Here's a quote from the case. The court acknowledges that district court review of these sweeping executive actions may be more expedient, but NTEU provides no reason why it could not seek relief from the FLRA on behalf of a class of plaintiffs. So the unions chose the wrong forum, and Trump can proceed. And I did mention earlier, this was an Obama-appointed judge. So I'm sure when this decision went through the news, somewhere Nancy Pelosi threw her Jägermeister against the wall and started yelling at Paul. And the thing is that Paul's not even there. He's probably in a different state. Also drinking, most likely. So the FLRA, the Federal Labor Relations Authority, this is a place that government employees go when they want to fight layoffs, but they don't want to work hard enough to work in private practice. That's this place. It handles labor management disputes for federal employees, and that is, of course, where the plaintiffs' unions must present their case in order to proceed forward. So I'm assuming they will go file something in front of the FLRA. Think of the FLRA as like a homeowners association for federal employees. Okay, they have lots of rules about what color your grievances can be. So in conclusion, just kind of to sum up, The Trump administration avoided a TRO or preliminary injunction because the court lacked subject matter jurisdiction. The judge didn't rule at all on the merits. He just kind of punted and said you need to file it in front of the FLRA. Now, I did a little bit of research on this. I have never practiced in front of the FLRA. I mean, I can barely say it correctly. I keep wanting to say FRLA, but I think it's FLRA. But I did a little bit of research, and the decisions can take 6 to 18 months with further appeals possible in the federal courts. And it looked like the more complicated the case was, the longer it could take. So I would think this one would be more on the longer side of things, which will be a while. Very different from trying to get a TRO where you might hear back in days, like weeks or days. Or if you have a really leftist progressive judge, you might hear back in hours, because we actually did have that happen. I think it was in that Doge Treasury Access case where it was unbelievable how fast the judge acted on that, wrongly. But anyway, so that's basically kind of to sum up that case. So even though the Democrats worked really, really hard to find judges who would all try to rule in favor of them no matter what, this case does show you that an Obama-appointed judge can follow the law, but only if the IRS is involved, right? I mean, this guy might just really hate the IRS, and that's why it's like, okay, I know the Get Trump jurisdiction should let me do this, but the IRS is involved, and I've been audited 4 times. Anyway, so that's that case. Thank you so much for watching. Thanks for watching my headlines and my shorts. And I need to say YouTube Shorts, because whenever I say shorts, it makes it sound like I'm talking about my shorts, and I won't do the same joke I did last time. But thank you for watching, and we will see you next week.
Please like, comment, and subscribe.